Yes, Mr. Morris.
My Lords, as we saw earlier in Ruddy and Oakfern, which is the leading case on these provisions, Lord Justice Jonathan Parker thought that the right approach was to construe the statutory provision, reach a provisional conclusion, and then to test the consequences of that provisional conclusion to see if any of them was so absurd that Parliament cannot possibly have intended them. So, adopting that approach, my Lords, my Lady, in my submission, if the words of section 38 are given their natural and ordinary meaning, this lease is a lease of a dwelling because it is a lease of a part of a building intended to be occupied as a dwelling. And so construing sections 18 and 38 in their legislative context, the provisional conclusion which I invite the court to reach is that the service charge protection provisions do apply to this lease. So then the next step is to test the consequences of that to see whether any of them is so absurd that Parliament cannot possibly have intended them. Now, I accept that on my case, there could be just non-residential use of the flat in question, and I accept that if there were no ancillary residential use and just office use, that at first blush may appear to be somewhat anomalous. But in my submission, Parliament has made a clear policy decision to extend the service charge protections to precisely such a case. And it has decided not to link those protections to actual occupation as a dwelling. And it is helpful to keep in mind what protections we are actually talking about here, which when the 1985 Act was originally enacted, were protection from being charged unreasonable service charges by the imposition of the statutory reasonableness cap in section 19, and the right, section 20, to be consulted before major works were undertaken. And so Parliament's decision not to link those protections to actual occupation has a number of relevant consequences. As we've seen, a lease of an empty flat will still enjoy the protection of the service charge provisions in the Act, as will a lease of a flat which is just used for storage of a tenant's belongings but is not in fact lived in. And an example I thought of over lunch, suppose, well, was my lady, this. A young couple in London each owns a separate flat, a long lease of a separate flat in different places. They live together in one of those flats. They both work from home, from the kitchen table, and so to avoid cross-contamination of Zoom calls, one of them each morning goes to the other flat in order to work from that kitchen table. In my submission, the fact that the flat was not left empty but was in fact used for Zoom calls and work during the day would not take it outside of the protection of the 1985 Act, the service charge provisions. And my Lord, my Lady, we can test this lease and the judge's conclusions perhaps against the extreme cases contemplated by the Court of Appeal in Ruddy and Oakfern. As we've seen there, the Court of Appeal was addressed on the possibility that a head lease of a shopping centre, which included a single caretaker's flat, would, if the tenant's submission there was right, would come within the scope of the service charge provisions. And the Court of Appeal was not affected by that possibility. That possibility did not dissuade it from holding that the Act would nonetheless apply. We take that from paragraph 60 and 74 of the judgment.
I'm not sure that the Court of Appeal did endorse that particular example.
Perhaps, my Lord, they didn't endorse it, but the point I'm making is that the possibility that
yes.
would follow did not lead them to think that it was a consequence so absurd that an interpretation contrary to the provisional conclusion should be preferred. So,
well, I agree that the court said, well, there are anomalies, whichever way you look at it. We can't really decide the case on anomalies.
Indeed, but this anomaly was firmly in the court's mind. So if we turn to page 101 of the authorities bundle behind tab 6.
Yes, well, the examples given at paragraph 52 on page 100.
Yeah, so that's the example, the lease of a shopping centre, which includes the janitor's flat.
Yes.
And then the tenant's submissions in response to that are recorded at paragraph 60 on page 101.
Yes.
And then what we see at page 74, despite the fact that that occurs in, sorry, paragraph 74, my lord, yes. Despite that anomalous consequence having been put firmly in the court's mind, the conclusion of Lord Justice Jonathan Parker is that there is no satisfactory reason for construing section 38 so as to exclude a tenant from the definition merely because whilst he is the tenant of a dwelling which extends only to part of the building, he is also the tenant of other parts of the building, be such other parts dwellings or common parts or some other type of property altogether, e.g. commercial property.
Yeah.
And then again down at paragraph 76, the judgment pivots into the testing of consequences. And at paragraph 80, we have the conclusion, nor am I assisted by the array of potential anomalies paraded on each side. And indeed, what Lord Justice Jonathan Parker says is that the greatest possible anomaly would appear to be that to which His Honour Michael Rich QC alluded in paragraph 5 of the Lands Tribunal decision, which is recorded at paragraph 56 above.
Yeah.
And if we look at 56 above, that in fact might be thought to be an anomaly going the other way. It's back on page 101.
Yes.
So he didn't endorse. The Lord's right. He didn't endorse.
He didn't endorse it, no. And I'm sorry, I wish to be very clear. I'm not suggesting that is part of the ratio of this decision. The point I'm making is that all of these anomalies, which in a rather nice sort of phrase on page 96, paragraph 39, Lord Justice Jonathan Parker described as please, or described the parade of anomalies in a different case as pleas ad misericordiam, which have found an echo in the arguments on this appeal, which might suggest something about what he made of their utility.
Yes.
Nonetheless, that adverse consequence was in the court's mind and it did not dissuade it from reaching the conclusion that the lease of multiple units was within the scope of the Act. So, in the light of all of that, in my submission, there is nothing shocking, or to use the language of Lord Justice Jonathan Parker, so absurd about the conclusion or the consequence which I've accepted follows on my case to require the section to be construed any differently. On the other hand, if we weigh that against the consequences of the appellant's case, which it seems to me, as I alluded to at the start of my submissions, are this: if this lease, which expressly contemplates the use of the premises for ancillary residential purposes, is outside the Act, then no unit at which a person lives and works can ever be a separate dwelling for the purposes of section 38. And that would exclude all live-work leases of individual units from the protection of the service charge provisions in the 1985 Act. And that, in my submission, would be a far more surprising consequence, because it would, in effect, involve the removal of protections, or rather, would involve concluding that the protections do not extend to individual tenants of flats whose leases contemplate them living and working in those flats. And so for those reasons, my submission is that the policy balance favours the wider interpretation of section 38, which both of the judges below adopted. So that is, in my submission, the basis on which the provisional conclusion, which I invited your lordships and your ladyship to reach, should be endorsed. As a final sense check, perhaps, it might be helpful just to test the judge's conclusion by framing the question in the negative. And the question then is this: why should the respondents not enjoy the service charge protections of the 1985 Act? Mr. Anvari, the first respondent, was one of the original tenants who, in 1989, took a lease of 999 years, for which a substantial premium of £462,000 was paid in 1989. The reference to premium is in the lease. It's on page 26 of the supplemental bundle. The lease incorporates expressly a service charge machinery, and it expressly contemplates the unit being used as a residence provided ancillary to office use. And why, in particular, should the first respondent not enjoy the protections of the Act, given his evidence that he intended to reside in the unit after his retirement? That is paragraph 13 of his second witness statement in the supplemental bundle on page
Well,
147.
none of that's been tested. I don't know. I'm not sure that we can necessarily accept that.
Except, my lord, it's not been tested. It was nonetheless the evidence before
Yeah.
the judge, and I feed it in just to the hypothetical series of questions that I'm asking. But if we take the example used by the judge in the judgment below, why should a barrister who used these premises as her place of work when not in court, and also as her residence in London, not benefit from the service charge protections of the 1985 Act? Or perhaps to use a more common example, why should a person using these premises for the purpose of running a small startup or a small company involving just one or two small number of employees coming and working from the unit during the day, not benefit from the service charge protections of the 1985 Act? Given the underlying policy, given the wide reach which is intended by Section 38, in my submission, the judge's conclusion tested against all of those questions and propositions was entirely correct. And so, just by way of concluding, I started my submissions earlier by saying the essential question on this appeal is whether Parliament intended that Section 18 and Section 38 should extend to a lease on the terms of this lease. And my submission is that the answer is a clear yes. Because when Parliament in 1987 amended Section 18 of the 1985 Act to apply the service charge provisions to the service charge protections to leases of a dwelling as defined by Section 38, when it removed the requirement for there to be a lease of a flat, i.e. for a lease of property occupied wholly or mainly as a private dwelling, it did intend that a lease of a unit whose terms permit the tenant to live and work in the demised premises should be subject to the service charge provisions which it enacted. So those models, my lady, are my submissions, unless there's anything else which I've conspicuously failed to address.
Thank you very much, Mr. Morris. Yes, Mr. Loveday, do you wish to reply?
Comes to bullet points. My learned friend began and ended, I think, with anomalies or surprising consequences. One of the points that we would, in fact, adopt the one that he referred to and then attempted to knock down, the possibility that these premises could in fact have never been occupied could only have been occupied for business purposes and never any vestige of residential. That is the position within the lease, the user covenant, and that going on for very many years. And then the lessee turning round after very many years of management as commercial service charges to say that they have the statutory protection. That is incidentally, of course, what the applicants say is the factual situation here, because the premises and all of the other units at Cloisters Business Park with similar covenants have always been managed in that way.
Do we know that the other units in Cloisters have similar use covenants?
There are certainly some other covenants.
Is there evidence about that?
There's no evidence, no.
Right, well then we don't know.
But the simple point is that the suggestion made by my friend does lead to my submission a surprising consequence of exactly that. That's the pure office user would be protected by the 1985 Act.
That rather begs the question. Maybe they are if they're all dwellings.
The other point that I would make is, if one recalls in Tan and Satowski, in Tan and Satowski, there was an absolute or a requirement for a specified business user, and that was the only requirement. In fact, the court implied a term, a user covenant. So even an absolute covenant does not, on the face of it, protect the landlord and regulate their affairs. So I would just mention that as well. But in any event, turning to the other, two or three other, several other points that are made, I did say I'd respond to my friend's submissions on Ezekiel, and you referred to the explanation of the reasoning behind the separate premises provisions of the Rent Act. Given the facts in Ezekiel, which was to do with enjoyment, the premises were not on the face of it self-contained, but there were rights to use facilities outside the bedsit rooms. It's perhaps not surprising that the court focused on that as being the policy reason behind the separate, behind the relevant provisions relating to separate premises. They approached it in the light of what the question was that they had to answer. This issue about mixed-use premises within a single space is not one that, as far as I'm aware, has actually come before the courts other than in this case. Yeah. And it may well be that the underlying policy might well be expressed in a different way in the light of the facts in this case. The restrictive covenant point, we say if the parties had intended to reflect the restrictive covenant, they would have used the wording of the restrictive covenant, not a very different formulation to the covenant in the lease. And we say that can be put on one side. As far as clause 16.2 and the dining point, if you remember, we say that is entirely neutral. One can dine in offices just as you can dine in residential. Change of character. Now, when I was in my submissions earlier on this morning, I struggled slightly to put my finger on exactly what the basis of my argument was, that there was a way in which the initial treatment of premises as being a separate dwelling could actually change during the course of the lease. But it's actually dealt with in Tan versus Satowski as a second point at page 121 of the authorities bundle. And it expresses it far more elegantly than I could hope to do. If you look at the subsidiary point, paragraph 78 and 79, you can see, I'd like you just to read that.
Yes.
So it's interesting the way it's put, that this is the basis of what I was saying about that with the landlord's positive assent, the designation can change.
So let me just see if I've understood this point. We start on the basis that the unit was at the date of grant of the lease, the unit was not intended to be occupied as a separate dwelling. That's the starting point. If during the currency of the lease, it becomes used as a dwelling, the initial non-dwelling character will not change unless the landlord assents to the change.
Yes.
Does it follow conversely that if the unit at the inception of the lease was intended to be occupied as a separate dwelling, that a subsequent change in the mode of occupation would equally not change the character of the letting without the landlord's assent?
Well, it could go either way.
In
It could
what
become
sense?
a separate dwelling, or it could cease to be a separate dwelling. Now, factually, neither of us are asserting that that has happened in this case, but it answers the question about, and it encompasses a number of the questions that you have asked, that you put, in particular the alterations points, because it matters not whether there have been mere alterations, even permissible alterations. What is required is for there to be a positive assent
Yes, I see.
by both parties to it being ceasing to be a separate dwelling or becoming a separate dwelling. Now, the same point was also made in Baker and Turner, and perhaps I could just pause there. You'll see that in paragraph 79 of Tan and Satowski, there's a reference to Wolf. Now, Baker and Turner makes the same point at page 36. Of the bundle of authorities, and actually quotes from Wolf.
Yes.
And in the middle of the page, it's Lord Justice Evershed. Less as a separate dwelling must refer to the subject of contract of letting. If it's to be shown that particular premises come within it, that definition, prima facie, at any rate, it seems to me it must be shown that two parties to the contract have let on the one hand and taken on the other the premises in question as a separate dwelling. That may be shown either by the terms of the bargain, or it may be shown where one other party has altered the user with the full knowledge of the other, by that party accepting the changed position, so that you must again imply a mutual consensus of the two parties. But it does require something quite substantial, if I could put it that way, in terms of the assent, because as was pointed out in Tan and Satowski, it's not just a question of waiving a breach. That also answers the partition question, the answer about what about putting up a partition. It's accept that there is a separate point here. The partitions, the appellant accepts that there is a provision in the lease, paragraph 9 of, I think it's immediately before the user provision, and it's that temporary partitions and alterations and non-structural alterations can be carried out without consent. So it's an unqualified covenant for alterations of a non-structural nature. But where does that leave us with paragraph 1612 in the supplementary bundle at page 44? Because 1612 says not at any time to use the demised premises or any part thereof. So that would include the post-partitioned premises for residential purposes or sleeping accommodation. And if we're right about the meaning of 1612, that would preclude residential purposes or sleeping accommodation of the partitioned part. And finally, on the last anomaly point that was made, the main thrust said that one's got to be careful about deciding cases on anomalies, and I'm trying my best not to run out a whole series of anomalies, but the live-work unit anomaly is on the appellant's submissions, not one that would arise, because we say that if there's a predominant or substantial test, that prevents every live-work unit. And the phrase is not a term of art, so we have to be very careful about that. Some live-work units are work-live units. But it would, if one can put it this way, mixed-use premises would be engaged by that. I mean, that would not mean that everywhere along the various scale of contemplated users would always be engaged. There would be a predominant substantial test, or the de minimis test, the Cheryl, the test that I've derived from Cheryl would actually prevent that anomaly occurring. Unless there's anything else, those are my submissions.
Mr. Loveday, can I just thank you very much for lending me your clip of authorities, and apologise to both sides for not having realised I got ready.
I'm obliged.
Yes, thank you very much. Well, as Lord Justice Newey said, there is a point of principle here. So we will reserve our judgment. You will get a draft in the usual way. It comes with a fierce embargo, which means what it says. So it can only be distributed to those on the distribution list that we have received. It will be your opportunity to correct our English, but not our reasoning, and not to introduce new points. We would hope that in the light of the draft judgment, you will be able to agree an order disposing of the appeal. But if you can't agree a form of order, please make written submissions, and we will, short written submissions, I should say, and we will make the order that we think is appropriate. The eventual hand down will be done electronically by distribution to those on the list and by release to the National Archives, so there will be no need for any further attendance. Thank you all very much.
Court round is able.